All right, so big in the news this week is the Nanny murder trials here in New York City. Lucia and Leo Krim, ages 6 and 2 years old. They were stabbed to death by their nanny over 2 years ago. The nanny's name was Yoselyn Ortega, and the stabbing allegedly happened in the parents' Upper West Side Manhattan apartment on October 25th, 2012. Her criminal trial is coming to a close right now in Lower Manhattan, a few blocks from our offices here at the law offices of Spar Bernstein in the New York State Supreme Court. It lasted almost 7 weeks. On April 18th, after a day and a half of jury deliberations, Yoselyn Ortega was found guilty of all 4 counts of murder, 2 counts of first degree, 2 counts of second degree murder. She is set to be sentenced on May 14th. Here to break it all down and discuss it is our criminal defense attorney extraordinaire, Paul Hirsch from the Spar Bernstein criminal defense team. Paul, how are you?
Good, Brad. How are you?
And thanks for coming on. You haven't been on in a while?
Yep, been a little bit.
Yep, I appreciate it.
Working hard.
Yep, very good. I'm glad you are. So now let me ask you a question. Give us a little background for those who don't know about this background of this what is in essence what was described in the newspapers to be a horrific case of a nanny stabbing to death 2 little children. Tell us what happened.
Well, this was horrific. This was back in 2012. The nanny had been working for the family for almost 2 years. And the mother took the youngest child to swim class. And when she came home, found in the bathtub her 2 other children full of blood and obviously deceased.
So now this was a 7-week trial, Paul.
Yep.
What took 7 weeks if it was really an open and shut case?
Right.
I mean, we're talking about an open and shut case here. What took 7 weeks? What is the criminal defense putting on for 7 weeks?
Right. Well, all cases boil down to 2 aspects, really. What happened and then why, and the intent. And so here we knew what happened. No, there was no argument as to how they died, where they died, who actually did the stabbing. This all came down to what was in Miss Ortega's mind at the time she committed these horrific acts.
So what was the arguments for the prosecution? Obviously the arguments was that she walked into the bathroom and she intentionally murdered these children. What was the defense arguments?
Defense argument was that she couldn't form the intent because she was not of sound mind at the time she committed the acts.
So when you say you can't inform the intent, what does that mean? I mean, she obviously intentionally did something.
Yes.
All right. It just didn't happen by happenstance. She intentionally did something. What do you mean in the legal term that she couldn't form the intent to murder these children? What does that mean in the criminal defense courtroom?
Sure. A case like this boils down really to the testimony of the experts. Both sides called expert psychologists and others in the field who either interviewed Miss Ortega in the 6 years since this incident or studied reports of people that interviewed Miss Ortega and gave their opinion as to what her mental capacity was at the time the crime was committed. And the jury needed to decide whether Miss Ortega lacked the substantial capacity to appreciate the nature and consequences of her conduct, or that such conduct was wrong.
So here's what New York State penal law says, Paul. I'm reading it here. It says a person lacks criminal responsibility, all right, because they're arguing over her mental illness. And what New York State says is a person lacks criminal responsibility by reason of mental disease or defect when at the time of the prohibited conduct, which would be the murder of these children, as a result of a mental disease or defect, that person lacks substantial capacity to know or to appreciate the nature and consequences of such conduct or that such conduct was wrong. So the defense would have to argue she didn't realize when she takes a knife and puts it into a child's body that child will die.
Right.
Or that when she picks up a knife and puts it into that child's body, that's something that we don't do here in America or anywhere in the world.
Right.
So what is the arguments for the defense to say she didn't understand by doing this? I mean, that's a big burden to overcome there.
Yes, it is, and these defenses are rather difficult and are not successful often. This was a horrific case. At some point, the defense has to put on something, and so decided to have experts examine her and testify that she didn't know the conduct was wrong. I'm not sure how you necessarily prove that or show that, or that she didn't understand that what was going to happen would result in what happened. A difficult road to hoe.
So when the criminal defense attorney Valerie Van Leer Greenberg, she was assigned to this woman.
Yep.
She was paid by the state to represent.
Yes.
She was objecting quite a bit during the cross-examination of Kevin Krim's testimony. Kevin Krim is the father of these children. Is this a strategy that you normally use to go object all the time of basically the victim of the father of these children? What would be the purpose of doing all of those objections? How was that helping this nanny?
Yes, the only thing that you would be doing that for is to set up an appeal, that you believe that either the father's testimony was irrelevant here and was unduly prejudicial, and you objected to have him testify at all, and once he was allowed to testify, you object each and every question to show that every question is unduly prejudicial, and therefore hopefully establish something on appeal about this trial.
So did you get a chance to look at this at all? What was the demeanor of Ortega in court? That was the nanny who was accused of these murders.
Yeah, I mean, her demeanor was fairly, down the middle. I mean, she was not obviously remorseful, and she was not laughing during the testimony. She was, there were no strange outbursts from her or anything of the sort. She seemed to sit rather stoically when rather horrific testimony was given, and really only showed some emotion when one of the defense experts testified about their conversations with Miss Ortega.
So ultimately, the prosecutor, the defense said, the devil made her do it. She said, I heard voices in my head.
Right.
And apparently the jury did not buy that from at least the defense expert witnesses who said that she was insane. She didn't have the capacity to understand when she picked up a knife and put it into a child's body that would cause the child's death or that was wrong. And she was hearing voices in her head. The jury didn't buy that argument. Apparently, the parents of these children were extraordinarily sympathetic.
Sure.
I read here that Marina Krim screamed out, that's Marina there, during her testimony, "You're a piece of work," she told Ortega. You're evil, and you like this. You're getting pleasure." Now that actually would show somebody who doesn't appreciate that they did something wrong. But that obviously didn't sway the jury in the end.
Right.
And now let me ask you a question. So the jury during this entire process, they saw a lot of horrible things.
Yeah.
Have you ever been in a situation, or because you've not only been a prosecutor in Brooklyn, but also now criminal defense attorney for 20 years, where something was so horrific that the jury had to have some sort of help after? The courts help jurors? I would think that I would need to speak to somebody after this. I wouldn't be able to sleep well.
Well, I guess your jury payment of about $18 or $20 a day should cover whatever psychological treatment you may need. But seriously, no, there's nothing really set up to help a juror who has seen some horrific images and heard some horrific testimony. I've had some trials, some homicide trials, in which there was some graphic testimony or pictures, and it's not easy.
So, have you ever had a situation where you had to pull the defense, my client's insane, that's why he or she did it?
Yes, I have.
And tell me about that.
It was a rather horrific, without getting into too many gory details, but a gentleman sexually assaulted someone and then set the house on fire. And it was, thankfully, no one was hurt additionally to that, and the fire was put out fairly quickly. But we did believe, after having experts examine our client, that they did not understand the consequences of their actions.
And
we were not successful.
You were not successful. It's very hard, you would think. It would be very hard to prove. What is the standard of proof that you have to prove? Because you have to prove. The prosecution has the burden to prove beyond a reasonable doubt this woman murdered these children. It was quite obvious based on everything that was discovered.
Right.
The woman was there in the bathroom. She was discovered by the mom of these children standing on top of her murdered babies. The fingerprints on the knife had the nanny's fingerprint. It was beyond a reasonable doubt that this nanny killed these two children. What is the standard that you would have to prove now that this insanity defense, which was not successful, would prevail?
Well, and that's what's very difficult about a case like this, because it's an affirmative defense. And although normally a defense attorney doesn't have to prove anything, right? It's the government that has to prove their case beyond a reasonable doubt. Once you decide to move forward with an affirmative defense like this, the burden shifts to you to prove beyond a preponderance of the evidence that this insanity is what took over, and that's what caused this.
So it's not, you don't have to prove, the defense does not have to prove beyond a reasonable doubt that this person was insane.
Correct.
Preponderance of the evidence is very interesting.
Right.
The prosecution has to prove beyond a reasonable doubt that this nanny killed these children.
Correct.
And then it was for the defense to prove that 51% of the evidence says he's insane or she's insane. In this case, she's insane. And 49% says she is sane, not insane. And in this particular case, they weren't even able to prove by a preponderance of the evidence, which is 51 to 49.
Which is lower, yes.
Right, that she was insane. She certainly looks crazy.
Yes.
Being crazy and being not remorseful does not mean you don't appreciate what you're doing, or you don't understand that sticking a knife in somebody's body would kill them. There's a big difference between saying I'm crazy and I'm insane.
Right. And clearly there's some mental health issues here. I mean, no one is going to claim that Miss Ortega is in her right frame of mind or is not in need of mental services, but did it rise to the level where your intent is negated by this mental disease or defect? Now,
she has her sentencing May 14th, Miss Ortega. Do you have any doubt that she's going to be given life in prison?
No.
She's going to be going to jail forever.
She will never see the outside of a prison cell. She will get consecutive life sentences.
Was she offered any plea deal that you're
I don't know. I wouldn't think so.
Right. Do you ever seen like these high-profile cases like this, a prosecution? It's pretty open and shut case. Look, I don't know whether they said 50 years and we'll let it go, or I would think a case like this gets tried 99% of the time. Why do prosecutors offer a plea deal then?
Look, sometimes you don't want to put the family through this, right? If the defense is if the individual is willing to take a 50-year sentence or a life sentence, maybe they offer 25 to life instead of 25 to lives to run consecutive. Maybe you consider taking something like that. You spare the family, you spare everyone the expense of trying a case like this. This trial was very expensive. You're talking 6 years since the date of the crime, expert upon expert upon expert. The prosecution costs money to prosecute a case like this, and the state paid for the attorney.
They probably spent millions of dollars.
Millions between both,
dollars.
Because the city paid for both.
Yeah, and then there's going to be more millions because there will be an appeal.
There will be a
appeal. And the Kims, apparently, they didn't want to give any plea deal. They came willingly and testified. They didn't need to testify to get this woman prosecuted.
No, they certainly didn't.
All right. Paul Hirsch, thank you very much. I really appreciate your time. Come on more often, please. He's a fantastic criminal defense attorney. He's right here at Spar Bernstein. For all people who need criminal defense, you give us a call right now, 1-800-529-5465. And for all people who don't think that they're going to be in the wrong place at the wrong time, now obviously I doubt anybody watching right now is going to go off and murder children, but you always find out, hopefully, but you always find out that you need a criminal defense attorney at the most inappropriate time, which is when the police are there.
Right.
Always save our number. Always have really good criminal defense attorneys, especially right here in New York. You never know when you're in the wrong place at the wrong time. I am telling you, this guy right here next to me is an awesome, fantastic criminal defense attorney, former prosecutor in Brooklyn, and now criminal defense attorney for the last 20 years. Paul Hirsch, thank you again.
Thanks, Brett.
And his number is the same number to reach us here at our firm, 1-800-529-5465. Thanks.